Jeff, let me ask you, from a cross-examination perspective, when we go to court, usually we're in and out. In other words, we're attacking and we're focused on a number of theories. For example, investigator, you do accident reconstruction, did you not? And you did that in this case. And you made certain assumptions based upon that, right? For example, you measured the drag factor. You testified it was that friction. And in fact, if your equation was off, the speed of the vehicles would be off. Isn't that true? And you go through the long list. What do you think? I mean, has the defense made crossroads in your view, Jeff, in terms of maybe, allowing the jury to know that maybe Snellgrove isn't all Snellgrove is really tied up to be? What do you think about that?
I don't. I think that they've, frayed a little here and there on the edges, as you do in cross-examination, but made nothing that says to me that they've got a winner here, and they better do something in their case. He seems to be forthright. He's going according to the book. He's not saying anything that makes him sound pompous. He's a death by order investigator, a vehicular homicide investigator. That's kind of special. You could make him look pompous in some circumstances, and he hasn't come off that way. And so I don't think the defense is doing very much. They're talking a lot about the seatbelt. There's reasons for that, again, because the more of an accident there is here, the more he's injured the defendant, the less the observations mean much. But it's just around the edges, Joey.
And, it's critical, because what you want to do, you don't need edges. You need to focus right on like a laser beam here. And, Jeff, you mentioned something significant, and Mike and I were talking about this, and we could talk about it again. Mike was talking about how he's plain spoken. The jury likes him. He builds up a rapport. I mean, that's significant, Jeff, is it not, with regard to whether a jury evaluates your testimony, believes in what you're saying, and credits what you say?
I do think so. I think he's matter of fact is the way I would say it. And I think that that's building the state's case block by block. I think the defense is not really attacking it in a way that a jury understands what their point is. There's a point, to be made around the corner. Maybe they'll take some of these facts together in closing, but it's not becoming clear. They're not hitting it, as you said, like a laser, and making it very clear to the jury what the defense is in terms of this witness anyway. And you need to do that. You need to have a theme, and you need to hammer it with every witness.
Absolutely.